Good morning to all of you. Jurisprudence class number 21. In this video, we are going to discuss exclusively regarding the custom as a source of law. In the last video, I have just touched the topic of custom. What is a custom? First of all, you must know. So please remember, the custom is a practice allowed by the public at large from the time immemorial. 3 points. So, customary practice, it should be in practice. Number 2, should be in practice from the time immemorial. And the persons, we can't get the persons who has proposed the custom. And slowly, it is taking the shape of law. Customary law. Very simple example I will tell you. According to section 5 of the Hindu Marriage Act. So the conditions for marriage, 21 years, 18 years, like that, all these things are. But can a girl marry her father's sister's son? As per section 5 Act, no. But it can be done as per the customary law. In that section, it is provided the custom accepts, he can get married. So customary law. Customs slowly have become the law. Why? Please remember, the custom plays a vital and important role in the entire world for making the law. Please remember, India, Islamic countries, so many customs, they have followed the customs. Even for that matter, when the Britishers, they wanted to codify the law, they have also learned about the customs of different people in different parts of India also. So why do we say that custom can be taken as a source of law? Because normally the people have followed the custom without any force, because it is treated as voluntary. Voluntarily they followed. And second point, this has come out from the opinion of the public. So of late, the legislature or the law adapted the same, but it has been followed voluntarily from the opinion of the public. And please remember, the custom was followed by our elders, and now we are following the same. And in future, our next generation may also follow the same. Like Kanyadana, Saptapadi, Mangalasutta Dharana. There is nowhere it is mentioned that you have to tie the thali for marriage ceremony. But the custom requires, so therefore it has become customary law. And please remember, previously, the religious preachers, the religious heads, they used to tell the customs actually as a part of the good principles. So please remember, custom is only a source of law. It's not law by itself, because there are bad customs. Sati Sagam, it's a bad custom, it's not allowed by law. So please, it is only a source of law and not law itself. That's why custom is to society, whereas law is to the entire state. Because even though we say it is against law, but custom is stronger than law. For example, Dowry Prohibition Act 1961. So our custom is to take dowry. As a father of girls, I have given dowry to my daughters. Giving and taking dowry is a custom. Even though the Dowry Prohibition Act is there, it has become in vain. Anyway, the custom prevails. Now, we are going to discuss how a custom should be. Requisites of a valid custom. Number 1, custom must be reasonable. So unless it is reasonable, the legislators and also courts will not recognize. In this connection, section 13 of the Indian Evidence Act, section 48 of the Indian Evidence Act. Yes, section 48 says that if any custom is there, it can be proved by witnesses before the court of law. Custom is accepted. So please remember, custom should be so old and still in existence. That's why time immemorial. The custom must be stable, must be certain, must be reasonable, must be continued, must be unaltered, must be uniform and consistent. And lastly, custom should not be illegal. This is more important. And different types of customs. Family custom, local custom, conventional custom, general custom. Different types of customs are there. Family custom. So normally every family every year reason-wise, this family reason-wise, the family custom and local custom. The family custom is prevailing in only one particular community or one particular family. So if there is evidence that this custom is being followed by the family, then it can take the shape of law. Because an important case I am going to discuss. Collector of Mathura, M-A-T-H-U-R-A versus Muthu Ramalinga Sethupathi 1869. Not now. That's why I told you, when the foreigners, when the English people, they wanted to codify the law, they have moved in different places and they have discussed with the local people and came to know about the customs. So this case will clearly tell about the family custom. So there is a Jamindar for Ramnad, a male Jamindar for Ramnad. Incidentally, without children, he died. His wife, Madam Parvati Nachiyar. So according to their family custom, she has adopted one boy. But there is some restriction that a widow cannot adopt the children at the particular time. But their family custom is, yes, they can adopt. But what the collector of Mathura did is, on 29/8/1868, the collector of Mathura actually has taken over the entire property of the Ramnad Jamindar, treating as an intestate. Nobody is there to claim. So if the no legal heirs are there, it is vested with the government. So ఇక్కడ ఆయనకి పిల్లలు లేరు కాబట్టి ఈ పెంపకం అనేది ఇంగ్లీష్ లా ఒప్పుకోదు కాబట్టి మొత్తం కలెక్టర్ గారు ఇంగ్లీష్ యొక్క ఈస్ట్ ఇండియా కంపెనీకి వెళ్తుందన్నాడు, ఏదో ప్రభుత్వానికి వెళ్తుందన్నాడు. వీళ్ళు కేసు వేశారు, అప్పీల్ కూడా వెళ్ళారు. సో అప్పీల్లో కూడా ప్రీవీ కౌన్సిల్, ఆ కాలంలో ప్రీవీ కౌన్సిల్, దే హావ్ క్లియర్లీ స్టేటెడ్ దట్ ద కస్టమ్ షుడ్ బి యాక్సెప్టెడ్. దిస్ ఈస్ ద ఇంపార్టెన్స్ ఆఫ్ ద ఫ్యామిలీ కస్టమ్, కస్టమరీ లా. Second point, local customs. So local customs are binding only on the local people, not on the other people. Local custom. So normally, certain areas they will have the custom. So suppose the custom of one village is that they will go to the house of Mr. Naidu to get the Mangal Sutram. The customary practice is, before taking the deity for the procession in the village, they will go to the Reddy's house. And people, they take the so-called water, they draw water from certain bavi, certain well. This is a custom. These are all local customs. So please remember. And third one is general custom or conventional custom. Conventional custom is normally it is through contracts in business. The conditions are used in the mercantile language. So that is a conventional custom. So general custom, please remember. So it applies to all. General custom, like the marriage ceremonies, marriage like Saptapadi, tying of Dharan. In India, almost all the people, they were particularly Hindu families. That is general custom. So please remember, there is a little bit difference between custom and prescription. Please learn. Custom gives the, please remember, it gives the legal provision. It can be taken as law, right? Whereas prescription, it gives a right. Please remember, right means only possessive right, not enjoyment right. It's a possessive right. So simply to say, custom means, suppose if you are going to a well to fetch water, so the custom it is being continued for 30 or 40 years. Yes, definitely, as per the easement's right, you will have a right. And suppose in a land you are growing some palmyra trees. The owner, even though he sees it, he did not raise any objection. After 12 or 20 years, he will get a prescriptive right. So this is the difference between custom and prescription. Of course, it's a different chapter. We'll discuss when the time comes. So friends, this is briefly regarding the customary law, custom as a source of law, why custom, what are the requisite valid points for a custom, and how can it be used as a source of law. This is the thing which I have discussed in this particular 10 minutes time. So I am concluding. Thank you very much.